Good afternoon. Phil Corwin, counsel of the Internet Commerce Association, representing domain investors and developers. I apologize for the fact that I'm really here to make a statement about process and not to ask a question that you have to sit there and listen to it, but that's the only opportunity we're afforded to deliver that message to ICANN staff and hopefully through them to the board. I heard Peter Dengate Thrush say a number of times in Sydney that the job, in his view, the job for the IRT was to develop proposed solutions and to see if they could get consensus support from the community. And I think it's clear to anyone who was at Sydney and heard the public comments there, who has reviewed even a sampling of the comment letters filed by last Monday with ICANN, that big pieces of the IRT report are very contentious, that there is not consensus support within the community. I'm not going to repeat our principal concern is a proposed URS. We believe it denigrates due process rights for registrants too much, and that is a major policy change that needs to go through a PDP. But I'm not going to repeat those substantive arguments. One, I said them in Sydney, and they're in our comment letter. And two, I don't think I'm disturbed by the questionnaire distributed today. The comment period closed last Monday, and either the comment period should be reopened for everybody to submit further comments based on what's going on at these meetings, or it shouldn't be open to just people coming to attend these meetings. Either there's a due date or there isn't, but it shouldn't, we shouldn't keep moving the goalposts and changing the rules as the process goes along. Now, some responded to remarks I made in Sydney by saying that our organization was not being constructive or was trying to obstruct the introduction of new gTLDs. Nothing could be further from the truth. All along, we've tried to play a constructive role. We have not personalized any of this debate. We have very strong policy reasons for disagreeing with parts of the report. We've endorsed other parts of your report, the standard sunrise approach and the clearinghouse with some modifications are things we can have no objection to. But we have said, and we would like a constructive, expedited process in the form of an expedited PDP to get everyone with concerns about the present UDRP around the table. There were very good suggestions from our side of the table of how to solve trademark owners' concerns about the current UDRP in regard to the 70% of default cases, how to make that faster and cheaper. And we think that that would result in a better, improved UDRP that would deal with current registrant abuses and complainant abuses. It would put it in place at .com and the other incumbents, which is where you have your major infringement concerns and probably will continue to have them for years to come, no matter what the success of this. And by doing it through ICANN's policy process, ICANN would be, frankly, insulating itself from a lot of potential litigation if they follow their own rules. If they want the community to support the bottom-up policy development process, then they should use it when there are major new policy initiatives. And if they want to be shielded from G12 of the internet takeover, when the US steps aside, they should not turn themselves into a legislative body inventing various new forms of trademark protection for which we don't believe there's sufficient support in existing law. So we're here to say that we're ready and willing to engage constructively and expeditiously in a PDP process which fixes the UDRP for everyone and puts it in place before any new gTLDs open for business. Thank you.
Thank you, Bill.